All right, we are on the record, the case of Synchrony Bank versus Kristen Alexander. This is file 20-08165GC. Counsel, please identify yourself for the record.
Good afternoon, Your Honor. Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the plaintiff.
All right, do we have anyone here appearing on behalf of Kristen Alexander or Kristen Alexander in person or in the waiting room, Katrina?
No, Your Honor, to either of the questions.
All right, Mr. Canine, have you had any discussions or is the case resolved?
Ms. Alexander spoke with someone in our office a few days ago. She committed to signing a consent judgment. We mailed it to her. Obviously, we don't have it back yet. So I was going to just request if the court would indulge me a 30-day adjournment today, please. I think we'll have it back by then and into the court.
Okay, let's do that. I think that makes some sense. Michaela, can we have a date about 30 days out? Date and time?
Yes, Judge. It looks like we're looking at July 7th at 2 o'clock.
July 7th at 2 o'clock by Zoom. And then obviously, Mr. Canine, if you have a consent judgment signed by then, we won't need to go on the record for that day.
Fantastic. We should.
Right.
Thank you, Your Honor.
Thank you. Is that your only case then this afternoon with me?
It is, yes. Thank you.
All right. Thank you. We'll be adjourned.
Okay, take care. Bye-bye.
Thank you. Next case, next status conference is the case of Citibank versus Aaron Triplett, file 21-08502GC. Counsel, please identify yourselves for the record.
Andrew Cates for the plaintiff, P78292.
Good afternoon, Your Honor. Philip A. Greenblatt. My bar number is 54170 on behalf of the defendant, Aaron Triplett.
All right, today's time of day set for a status conference. Have you attorneys been able to talk through the case? Is there a resolution that you anticipate, or do we need to set it for either a motion or trial?
I've actually spoke to the law firm representing, I understand counsel here today is stand-in. I spoke earlier with creditor counsel's office. We have a high expectation of a resolution, probably need with the court's indulgence a little bit more time to finalize the documents and submit it to the court. If there's any chance we could get perhaps 60 days or so, I suspect you won't see the parties here again.
All right. Mr. Katz, I know that you're filling in. I suspect that if we're asking for a timeout is probably within one of the purviews that you can consent to.
Yes, Your Honor. I've been apprised by the attorneys of record, and they were well aware that this adjournment was going to be asked for, and we consent to it.
All right. Michaela, we put it on. I will adjourn it this one time for the 60 days, but right after that, I'm going to have some resolution because we're starting to stack up on cases. So, Michaela, can we get something out about 60 days for the Citibank triplet file?
We are looking at August 4th at 2 o'clock.
August 4th, 2 o'clock by Zoom. All right. Thank you.
Excellent. Thank you, Judge.
Your Honor.
All right. We'll be adjourned.
Your Honor, I do have someone appearing by phone. If we could have them identify themselves.
Mark Rapanos.
All right. Thank you, Mr. Rapanos. Your case slot is at 2:15. I have another 2 o'clock yet right before yours. So we'll address that and then we'll get to your case. All right.
I'll just sit here, right?
Yep. You're just fine. We'll probably put you on mute and then we'll have you on mute when it's time. Now calling the case of Mercer Transportation versus Lynette Myers Brown. It's file 20-08199GC. Would the attorney for the plaintiffs please identify yourself?
Afternoon, Your Honor. Stephen Lynch, P70211. I'm appearing for the plaintiff.
All right. Miss Lynette Myers Brown, will you unmute yourself and identify yourself for the record?
Lynette Myers Brown, Outlaw Express Trucking, and it's MYERS-Brown, BROWN.
Thank you. Ms. Brown, Myers Brown, have you hired an attorney or are you still representing yourself?
No, I'm still representing myself.
All right. I do note that we had received in today's mail or email a document. Looks like it was from you, Ms. Myers-Brown. Did you happen to send a copy of this document to the other attorney for the other side?
Yes, I did.
All right. And Mr. Lynch, did you get a copy of the document? It's the correspondence that was filed with the court. Yes.
Yeah.
Let me show you. Go ahead. Yes, that's the document.
I received this yesterday at about 10 p.m., Your Honor. It's a 2-page, it says it's an affidavit. It's not signed or sworn to. And then the second page is what she claims is a
Telephone call from an attorney,
from
allegedly. Okay.
Right.
All right.
That's
So
what
today's time and date set for a motion for summary disposition as well as a status conference. Mr. Lynch, you had filed your motion for summary disposition. Ms. Myers-Brown, I did get that last document. Did you ever file an answer to the motion for summary disposition?
Yes, I did.
Just take a look. Michaela, do you have the case pulled up?
Yes, Your Honor. I'm looking to, I'm trying to see if we received an answer at the moment.
All right. Ms. Myers-Brown, I do see the answer to the complaint that was filed in April. And I do see the document that you submitted that we got today. I don't see anything between April and today. Do you know when you may have sent that?
Maybe it was my answer, admit, deny. It was to the amended summons
To the
and
amended
complaint.
complaint.
Yep.
Okay.
And
Okay.
and
I
as
do
far
have that.
as I'm sorry.
So I do have the answer to the amended complaint. And let me just pull it up and show you on the computer screen to make sure that we're talking about the same thing. Should be up by now. Is this what
Yes.
you're talking about?
Yes, that's what I'm referring to.
Okay. This one, I don't know if it's an empty page. It probably just looks like an empty page. Looks like it's an empty page about every other one. So you filed the answer to the amended complaint, but you did not file an answer to the motion for summary disposition.
No, I was after our status conference today, depending on how that went, I was gonna ask for a continuance because I'm depending on how it goes today, because I'm waiting for some documentation from out of state.
Yeah, the documentation would be helpful to the case somehow.
Yes, like on the original paper, the original filing of Mr. Lynch, that I was served the original summons and complaint.
Yes.
And then his answer dated February 11th, 2021.
Yes.
His answer on page 3 of his answers, it says under the analysis, it says down there, defendant refers Roush McMillan International in parentheses, or in quotations, I mean, several times in the motion, but that entity is not a party to this case. When we were in front of you the first time, you showed a document that I produced from Roush McMillan International, and on the summons and complaint originally from Mr. Lynch, where you go to Mercer Transportation and it says itemized statement of account. And it has termination date 3/1/19. And then when you go down to the very bottom of it where it says total due Mercer Transportation, And right in that little writing, it says, not including collection costs incurred through Roush McMillan International. So I was disputing this whole thing because this document was actually produced for Roush McMillan International, the first collection agency that inquired with me about paying this debt out of Louisiana. And I contacted an attorney in Louisville, Kentucky named Lynn Stone. Lynn had conversation with the debt collector, and the debt collector had conversation with Mercer, and that's how this bill arrived, was when my attorney requested it, because to this day, Your Honor, I have never ever received a bill after I terminated doing business with Mercer Transportation due to an accident that the truck and trailer was involved in.
Hit a cow, right?
Yes, in Kansas, Bourbon County.
Yes. All right. Mr. Lynch, your motion for summary disposition, sir.
Yeah, Your Honor, I don't really have anything to add to it. There's been no reply to it. I understand she's pro per, but she still has to file a
Your Honor,
response.
I'm sorry, Mr. Lynch, we're having a difficult time hearing you.
Okay, I can get closer to the microphone. Does that help?
I think when you're turning your head to read your document is where we have the problem. So if you want to put the document in front of you lower, I think we'll be okay.
Sure. All I was going to say is that I rely on my brief and my motion there, which has not been responded to. This is a simple collection action. I've attached the agreements that the parties entered into. Roush Milliken is a collection agency that tried to collect on this debt beforehand. I don't know why she keeps bringing them up, other than it's a red herring. It has nothing to do with this case. The plaintiff is Mercer Transportation, in which she entered into multiple agreements to rent a tractor and trailer that she was traveling, and she did her business as Outlaw Trucking. As part of that agreement, she was to pay lease agreements monthly. She had to pay insurance. She had to pay data packages. She had to pay all these things that are itemized in my motion, which she has not responded to, and which she has not denied in any of her pleadings. She keeps filing these affidavits, which make no sense to me and which cite Pennsylvania law and have no bearing on the case. Your Honor, this is like I said, a simple breach of contract action. There's an itemized statement and an affidavit to support that for $5,714.87 plus court costs. And as the agreement state, I'm entitled to reasonable attorney fees for having to bring this lawsuit, file an amended complaint, file the motion, and obtain judgment.
All right, Ms. Myers-Brown, your argument against his motion for summary disposition.
Yes. First of all, I did not rent a tractor from Mercer Transportation. A semi-truck, Mercer Transportation does not own semi-trucks. And he does not even have all of the documentation. The documentation, other than in his first summons and complaint, I have supplied. This first summons and complaint, it doesn't even have signatures. I've never received a bill from Mercer Transportation. I've just got collection companies coming at me saying, this is what you owe. And I'm like, what do I owe that money for? That's been my question from day one. What do I owe you money for? I broke a lease. I was in an accident. Mercer Transportation's insurance company has received over $30,000, and there is an ongoing case in Bourbon County, Kansas. It shouldn't be. I mean, I'm defending myself against a debt collection agency that Mercer's supposed to be their client. If Mercer is their client, then why don't they have all the paperwork? Because I'm holding a title to a Peterbilt that Mr. Lynch keeps referring to that's owned and rented by Mercer Transportation. And I do have that ready to send to you. You can see it's a Michigan title. It's titled to myself, Outlaw Express Trucking. And then the truck that was involved, the lease, it's not even in any of his paperwork but I'm holding it. It's a lease that says truck number 18688 is a truck that I own that was in an accident. I was lease purchasing a semi trailer, which was trailer number 18688A, which was a 2014 Fontaine, which was involved in the accident that Mercer signed off of, that said all the repairs were done pursuant to them. And then in his summons and complaint here, there's a Knowles truck service bill that's on the trailer. There's a trailer inspection report, and it's not even signed. But yet, when you compare this paperwork to my paperwork has original signatures, and my paperwork has actual numbers. So if Mercer is his client, where's their paperwork? And then this affidavit that he has here that is signed by this Amy McGill, that is supposed to be a Mercer transportation agent out of Mercer Transportation out of the state of Indiana. Mercer domiciles is in Louisville, Kentucky, and all my paperwork says that. I've never worked for Mercer out of Indiana, and I've never met anybody named Amy Gill at Mercer, and I've met a lot of people, especially considering the accident with the cow that's still ongoing. Because when I was leased to Mercer, I was also under their insurance, not my own. It was Mercer's insurance. It was called Esses. So I've just been stating the facts and denying his paperwork because this ain't original paperwork.
All right, hang on just a minute. Let me just ask a few questions, and I may have to adjourn temporarily so that we can get some other folks that don't have as many issues for me to think through and questions to ask, and we can see if we can get this addressed. Mr. Lynch, there was a request to amend a complaint, I believe, filed. Michaela, can you help me find the amended complaint when it was scanned in?
Yes, I'm looking right now. Also, Beth did send you an email, Judge. It was filed on 3/5.
All right, so if I look for that, there we go. Summons complaint amended, there we go. All right, let me just take a look at that real quick.
And the answer was filed on 3/30.
All right, thank you. I was seeing some of the documents that I wanted to look at. Ms. Myers-Brown, I want to share with you a little bit of the documents that I was looking at. In the exhibit that was attached to the amended complaint, a couple things that jump out at me. One is that the plaintiff indicates that they do business in Kentucky. I think that's what you said. Not Indiana, but Kentucky. Here it is. Does principal business in Kentucky. Then you had that there was an agreement between, it was alleged as an agreement between Mercer Transportation Corporation and Lynette Ann Myers-Brown. Then you had stated that the document that you received wasn't signed. Here, I'm showing a document on page 10 that has a signature, Lynette Myers-Brown, doing business as Outlaw Trucking, and signed by the owner, Ellen Kanzler. Here on page 34, I'm showing a document which is the power unit addendum, and it has signatures. Here, there's an appendix for trailer 2. On page 38, there's an appendix B that has a signature from 2019. This one is scanned upside down, but it has some initials on it. Here, I've got a certificate of insurance indicating what was going to be with initials. Here is a signature from the contractor, and the type of coverage is listed. Here's another one, appendix C, that has a signature. And this document here, which is appendix D, has signature with your address. It has the listed electronic signature of Sandra Brown, Louisville, Kentucky, authorized representatives, agents, and permits. Here is a signature.
Yes, Your Honor.
So I'm not seeing where you're saying that these documents don't have signatures. It does seem to have all the signatures on here.
Yes, I agree with all that. Them are all the documents that I provided in my answers. I'm referring to his original summons and complaint, his original summons and complaint.
Right. So hang on then. I understand what you're saying there. The original summons complaint, you may have a point, but I allowed the amendment to take place. The amendment did take place, and he provided the information. Whether you provided it to them or not, they provided it to the court, which means they provided it to you. And then they filed a motion for summary disposition, and the motion for summary disposition had an affidavit. Some of your documents that you provide are affidavits, and some of the documents you provided are not affidavits in response. An affidavit isn't one just because you say it's one. It has to be sworn and attested to, and it has to have somebody notarizing it. And even though you say, hey, I swear it's true, it's not an affidavit unless it meets all of the requirements of it. So the document you filed today was not an affidavit. You called it one, but it's not. The cases you cited looks to be cases from another jurisdiction, not Michigan, and not federal cases that this court's required to follow. And it is true, the attorney typically can't be a witness and the attorney in the case, but the affidavit that's submitted is from the company attesting to, under oath, by someone who says that they know that the information is true, and that can be used. And in a motion for summary disposition, once one's been filed and they've provided an affidavit, you can't just rely on your pleadings anymore. You have to file an answer to the motion for summary disposition. And you not only have to file the answer for motion for summary disposition, you would also have to file your own affidavit outlining some of the facts to dispute the facts. So in this case, you've not followed all the requirements regarding in the law. I am going to make the determination that the motion for summary disposition under 2.116C10 is proper, and I am granting the amount awarded to the plaintiff as pled and requested. So at this point in time, I will sign the order. I will award also reasonable attorney fees. However, the amended complaint benefited the plaintiff. I will not allow the time used for the amended complaint. I will allow the time for the motion for summary disposition, but nothing assigned to the amended complaint.
Okay, Your Honor.
So I will sign that order once it's been presented to me.
Very good, Your Honor. I'll
Your
file it
Honor,
with-
can we get that emailed to us, please?
So I can
Yes.
always object.
You have a right to appeal the decision to the circuit court
Okay.
or file a
'Cause-
motion under the.
Cause like I had stated in my original, there's the paperwork that you pointed out, Your Honor. It's missing the main truck. That is a lease on a Peterbilt. There was two
Okay.
trucks. And
Okay.
that the lease that you pointed out that I supplied, they don't have the documentation supporting their 18688.
Okay, and perhaps I'm wrong, but you could either do it for a motion for reconsideration and follow those rules or appeal. But as it stands right now, I am granting the motion for summary disposition based upon the documents submitted. So, Mr. Lynch, you need to send it to 75civil@co.midland.mi.us.
Very good. I will do that, Your Honor. Thank you.
Thank you. Be adjourned.
Be well.
Thank you, Ms. Mike Brown.
Thank you.
All right, 215 document. I am going to call the case of Mark Rapanis versus Kelsey Cooper. Mr. Rapanis, if you would please unmute yourself. And Katrina, do we have a Kelsey Cooper either in the virtual waiting room or in the physical courthouse? Katrina, you're muted.
Your Honor, I do not see anybody in the virtual waiting room. However, I do see someone in the lobby. I'm going to see who they are.
All right, thank you. Mr. Rapanis, if you would please state your name for the record.
Mark Edward Rapanis.
I'm going to wait to see who is here in the courthouse.
Got it. Okay, thank you. Your Honor, I did check the court lobby and no one is present with the name of C. Cooper.
All right, Mr. Rapanis, you're asking for a motion for entry of default judgment. Is that correct?
Yes.
All right, I'm going to grant that. The defendant has failed to appear and has failed to answer, otherwise defend. I will grant the motion for default. Judgment may enter. The amount you're requesting, sir?
$2,101.02.
All right, I will sign an order for default, the amount of $2,101.02.
We need
Will
the
be
cost
adjourned.
as well, Your Honor.
What cost do you have associated with it, Mr. Rapanis? Filing fee, service fee?
Yeah, so we'll just start right in the beginning then. December rent wasn't paid for $850.
No, we're not disputing the amount of money that you owe. We just want to know what cost. Yes,
You mean
the
after
cost
that-
for filing.
$94.40. We had court fees of $75. I also got an unpaid water bill that I had to pay that she didn't pay for $311.62. And
Okay.
the service for $40, which is how we got to the $21,0102.
Okay, that was all included then. So
Yep.
so we're gonna have to back it out, Michaela, back out $115 out of the $21,0102 and make $115 costs. So, Mr. Rapanis, we break it down to two different so people can see what the judgment amount was versus what the costs are
Okay,
as far as our document. So if the 21,0102 includes your filing fee and service fee, we're just going to back out that number and add it back in as cost. So the amount's the same at the end.
yep, I got it.
Okay. All right. We'll be adjourned on your case. Thank you.
Sure. Bye-bye.
All right. Thank you. The next case is Michigan Education Association versus David Zach. This is file 20-0809 GC. Will the parties please identify themselves for the record?
Good afternoon, Your Honor. May it please the court, Keith Cox of Ingber and Winters on behalf of the plaintiff, P59146.
Good afternoon, Your Honor. Jacob Lyday on behalf of defendant David Sachs. That's going to be a PA 4753.
All right, today's time and date, both for a status conference and for a motion for summary disposition. I've learned a long time ago to check with the parties first, because sometimes before we get too much into it, I find out they've resolved the case. That may or may not be true, but I find out that's a better way to ask. So have the parties resolved the case, Mr. Cox?
No, Your Honor. I think we're similarly situated as we were when we were before you last, which is to say not settled and plaintiff needing to proceed with its motion.
All right. Yeah, Mr. Lyday, you would agree with that?
I would, Your Honor.
All right. Mr. Cox, I'll allow you to make argument regarding your motion. And thank you, by the way, for submitting a legible document that the court was able to read. I can read this one. I don't think it scans well, but I do think that it is more legible.
Well, I appreciate that, Judge. Judge, we brought our motion pursuant to MCR 2.116 C9 and C10, as we don't believe the defendant has come forth with either valid legal defenses or questions of material fact. Judge, effective, in short, the passage of right to work gave the members of the union a pathway to get out. Prior to that, when Michigan wasn't a right to work state, you wanted the employment as a teacher, as the defendant was, you had to join the union. Now, in 2013, the defendant was given a pathway to get out, but that pathway involved having to opt out in writing, which the defendant never did. Instead, what the defendant did.
So where is that that says you have to opt out in writing? Is it on this document, which is Exhibit 1?
I think it's contained there, and I think it's also contained, on the MEA's website, and I think it was contained with.
Well, hang on. How is a person? I was curious about this. How is an individual bound by a agency's constitution and their website? People are bound by contracts, either they sign or agree to. I don't see anything in this application that says I'm going to live by the constitution of the MEA or their website, and I don't know of any case law that says you're bound by website and you're bound by constitution. Can you point that to me? I'd be glad to read it.
Well, no, Judge, but I think it's not unreasonable to have a procedure that where you opt out, you do so in writing. Otherwise,
I'm asking about the contract. Show me the contract where it says you have to opt out.
Well, within the language of the agreement, it does say that if you wish to revoke the authorization or the agreement itself does speak to that.
You're talking about the document at the top that says continuing membership application.
Correct.
Okay. So if the way things used to be before 2013, once you signed one of these things, it was like Hotel California. You can check out anytime you like, but you can never leave. You want to teach, you got to be part of the union. You sign the document, you're there.
The only exception to that was you could do something which was pay agency fees rather than union dues. Agency fees were sort of the equivalent of the dues, but perhaps you had an issue with the way the MEA was using its money or supporting political candidates or whatever it was the MEA did with its dues monies. There was an alternative called agency fees where they were making you sort of pay the rough equivalent of that. But yes, in effect, what Your Honor is saying is accurate, which is sort of what I sort of stated a few moments ago was, if you wanted to be in the job, you pretty much had to be in the union.
Okay,
so now I guess what the court's asking about the opt-out procedure.
That's what I want to know. So the contract that you're saying that signs you in is this continuing membership application. When you sign that, you don't have to ever sign another one.
Correct. I think they it looks like they might have you sign another one if you switch schools, just so that they can have that information be with it on the union record. And in fact,
okay, I'm glad you pointed that out because yes.
I apologize. When you had asked Mr. Cox how bound over to the agency and the website sign or agree to, I don't know if everybody heard because we all froze.
Okay.
I don't know.
We're unfrozen now. So let me backtrack just a minute. So The continuing membership application you sent to me, the one I have, the legible one in the box is most of the other ones legible, and except for that box that I think everyone's pointing to. And this is the one that looks like it was dated August 25th of 06, and it says Lakeville Middle School. And the one that's not so easy for me to read, which I think was part of the complaint, was from Gardner Middle School on August 24th, 2005. Are there any other documents other than these two?
Judge, no, what I think what we did was we sort of did a little bit of a patchwork there with regards to it. The original contract that we attached to plaintiff's complaint, you know, Brother Counsel and Your Honor both pointed out, was difficult to read.
Right.
And in response, when I asked my client, can I get a better copy of that? They're like, well, I don't know if we can get a better copy of that one, but here's the one that precedes it with the identical language, which was for the other middle school that he had taught. And what we did is we submitted that to the court.
Right.
The court could see the language and better read it because the language that appears on both of those documents is identical. So if you're reading it from one, it's the same language that would appear on the other.
Okay, so let me just make sure.
I think if you hold them up,
and I think that's
side by side, I think you can kind of see that.
Yeah, and I'm just going to check to make sure of what things we agree and disagree with. Mr. Lyday, I'm not asking you to consent or concede Mr. Cox's point. What I'm asking, though, is would you agree that the documents, even though we can't read the one from the middle school from Gardner, it does look like at least the same length of lines and the same type of boxes, the information that we can read from Lakeville Middle School and Gardner Middle School appear to be the same?
Yes, I would agree. I would agree with that, Your Honor.
Okay. All right. So go ahead, Mr. Cox. So as I'm looking at this, I presume the language you're saying that the people, once they sign this document, are locked into the union is in that next to last box, which is the bigger box that says, please check one about cash payment and payroll deduction. I think that's probably the area in the contract, or is there a different area?
No, plaintiff's position is that they determined at the time the manner by which you could pay your dues, but that plaintiff's position still was and still is that if you wanted to opt out of the union, you needed to do so in writing. And they were initially holding them to an opt-out window between August 1st and August 31st, which subsequently they relaxed and later have waived. The defendant, Mr. Zach, in this case, was not bound by any opt-out window. He could have opted out at any time in writing, but never did so.
Okay. But I'm still looking at the contract because that's what I have to determine. What's the agreement between the parties, because it's a breach of contract case, right? Unless I'm.
Well, it is, Your Honor.
So where in this contract
right.
does it say that you have to opt out? I understand that may have been the understood, but I'm looking at the four corners of the contract, not parole evidence. I want to know where in this contract does it say that?
Well, the contract, the only area in the contract that speaks to revoking authorization is in that area where the court was looking.
Okay. All right. So the position of your client is that he could have opted out. He chose not to opt out, and therefore he is bound to pay the whole time while he's teaching, or is it until, or is he does he have to pay union dues even when he's not teaching anymore?
No, see, that's the first thing I wanted to point out with regards to what we're alleging and what we saw in the defendant's response in his brief. You know, Judge, we show him as having retired from the union before the 2017 and 20 talks about him having left sometime in 2016 and then him in 2017. He's not being charged for any months that he was not a teacher with the school district. So the answer to that question is he's only being assessed dues. And if he disputes the fact that he was employed and gainfully employed and working as a teacher, I mean, that would be a question of fact. And I prior to the commencement of these proceedings before the last hearing, I did speak to Brother Counsel about that. And I said, listen, if you have documentation to establish that he was not working as a teacher through June of 2017, that I concede that would be a question of material fact. But our records reflect that he left the district after the 2016-2017 school year, which is the only year in which we're seeking dues from him. After passing his right to work, he made payments to the MEA, and there is a payment history contained in Exhibit 4 of the original motion. And what it shows is that he didn't, some of these folks, some of the members would not pay monthly. They would pay, some would pay in advance for the entire school year. Some would pay, unfortunately fall behind, catch back up, which seemed to be what was happening with Mr. Zach. If you look at page Exhibit 4 of plaintiff's motion, the ledger, which is not terribly user-friendly, but the third page of that document, it has a credit summary, and it lists all the payments that he made starting from when the ledger begins in 2014, 2015. And he had made payments to the MEA of $108.15, 108, 216.45, 200. In 2015, 2016, he paid $100, $200, $200. He made a larger payment of $675.85. In the beginning of, I guess it was actually the beginning of the 2015-16 school year, he paid $150. Then he paid $200, and into 2017, he paid another payment of $200. And what's interesting is the argument that they're making that these payments are voluntary. And what that sort of assumes, and I'm trying to figure out how payments could be voluntary, and yet him still want to be in the union, still paying for union dues and expecting union benefits. So I'm wondering, based on their argument, is it month to month, where if I pay my union dues that month, I'm in the union, I get benefits, but if I don't pay for a month, I'm out of the union, I don't get benefits? Because what I'm kind of hearing him say was, listen, I stopped paying, I guess, and so I was out of the union. The case law that we did cite, where the Court of Appeals said it is reasonable for the MEA to have an opt-out requirement, because to not have one would be the MEA, you have no idea who's in the union, who's entitled to benefits, who's not entitled to benefits, if there's no opt-out provision in writing that you put the MEA on notice of the fact that you don't want to be in the union anymore. And I don't think it's reasonable just to say I stopped paying because payments were voluntary. So, in that regard, I don't think that argument would hold up to say simply that the union dues were voluntary, as what was alleged, and his payment history doesn't suggest that either. And if you look too, we also attached to our motion the billing statements that were sent month over month relative to a balance that had been accruing, and he had been chipping away at it. You can look at the payment history, and the last payment being January 4th of 2017. So, Judge, I guess what we're saying on this is that he was in the union. He had an opportunity to get out. He didn't. And his failure to pay, his simple stop paying, that doesn't create a genuine issue of fact, nor did it really get him out of the union. And frankly, when he did, we finally stopped charging him when he actually terminated his employment or left the school district altogether. But what plaintiff is seeking is just payment for the months of October through June, October 16 through June 17, which on the ledger show are the months that he just did not pay his union dues.
Okay, so if I can show you, because I wanted to follow along with that payments, and Mr. Lyday, I'll give you an opportunity to say your piece here in a minute. I'm following along. This is, hang on just a minute. This is the sheet you were talking about with the credits and whatnot, correct?
Yeah, Judge, that's Exhibit 4.
Yes.
And it starts off, I appreciate it's difficult to interpret, so if the court has questions relative to the way that's shown.
Yep, so here's what I'm looking at. So I see a total, and then I see credits, and I'm trying to determine, because it keeps showing balances of 0. Does that mean that, it looks like here, 2014, 2015, there was a total of $1,081.50, and then credits of $1,081.50. So starting in the school year 2014, well, I'm trying to figure it out what exactly this means.
Okay, so Your Honor, if you're looking at, let's see, you're looking at page
1 of the exhibit.
Okay, page 1. So the way that, and I'm looking at it on my screen too, it's a little bigger. So where it shows credit 9/25/14, that's the date that payment was made, and then
there we go. Okay.
means by which
Mailed
payment
check.
was made, mailed check payment.
Got
And
it.
so what you'll see is that goes through all the way through all of the months. And what you also see is that he didn't necessarily make the payment on the month that it was due. So for instance, if you're looking at October of 14, you're not seeing him paying in November. And then he also paid later in February, and they made that larger payment in February. And those are the dates those payments were applied. But if you scan down and you get to the months that are at issue in this case, the ones that we don't show as payment, it goes all the way down. I guess you're on to page 3, because in the June of 16, the bottom of page 2, it says mailed check payment. And then we get to the last page, and then where it says balance transfer to collections. It does show a zero balance, but as is the case with a lot of collection actions and a lot of creditors, when they transfer to collections, they zero out the balance to balance the books. So what you've got here now is, it does say a credit, but if you notice, the credit is all the same date, and it's the date of charge off to collections. And that's why it says next to it, balance transfer to collections.
All right. So,
And I don't think Mr. Zach is alleging that he made a payment for the entire balance on July 30th, 2019. So what we're showing is those are the amounts that are not paid. And I don't think that's in dispute. The one thing we can agree on, I think, is that he didn't pay the union dues for the months that we are alleging.
all right. So if I look at this correctly, I'm looking at the third page of the exhibit. It shows the September 2016, there was a credit on January 4th, 2017 for $38.45 mailed check payment. Correct?
Yeah, Judge, the payment that if you scan down further on this same page and you go to only the bottom, the last payment that he made was for $200. And what he did was he had, at that time, overpaid a little bit of the prior year. So
I got to go up one sheet.
Well, yeah, if you look at the application of the January 4th, 2017 payment, which was $200, if you go back a page, you'll see that amount having been applied to the May 2016 dues and the June 2016 dues, one of $57.70 and then $103.85. So what he was doing was in January of 17, he had a balance, and perhaps that would show that he was even acknowledging the fact that he had this balance, because if you think about it, Judge, he got a bill that said, hey, in January of 17, you owe for May of 16, June of 16, September of 16, October, November, into January of 16. And in response to that bill, he didn't send something in writing saying, I am opting out of the union. He sent in $200. And that $200 was applied by the plaintiff to the May 16 bill, $57.70, the June 16 bill, $103.85, paying off those two in full. And then a portion was applied to the September 16 bill, which was also due of $38.45. Now that was the last payment he made. So of the September 16 bill, he owed $65.60, and then all of the dues for the remaining 9 months.
All right. So if you
want to look at
this one right
behavior,
now, the last payment.
Does that make sense?
Yep. So let me just make sure I got it straight. So the last payment, I'm hovering over on my screen here. It shows September 2016. It says they give credit. The date of the credit was for $38.45, but that was to pay for September 2016.
Yeah, Judge. So what happened was a $200 payment was made by the defendant on January 4th of 2017.
$200 payment. So let me go back.
So
okay, so I see 103.85. Okay, so 103.85.
If the court wants to see where the payment is reflected, you can look at the bottom of page 3 of Exhibit 4, where it lists all the payments. The court would need to scroll down, and it will show the payment where it says mail check payment.
All right.
To the far right there. Yeah, it's to the right. You actually can't see it. It's you'd have to go all the way to the right on the column. There. Yeah, and then you see at the bottom where it says $200. So if you follow the 1417 column across, that's the $200 payment, and all of the payments that he made during this time period are reflected. The total amount that he paid and that total column, and then there's subtotal along the way. But that $200 payment was made at a time when his balance was reflected of both dues owed for the tail end of the prior school year, which was the 2015-16 school year. And so what plaintiff did was he took the 200 and it applied it to May of there of 5770, and it applied it. Now we're on page 2 of Exhibit 4. And if you look there in May of 16, it took a portion of that $200. It basically, Judge, it took that $200 and spread it out over 3 different months.
Okay.
It paid off what was due and owing in May of 16, which was 5770. It paid off all of June of 16, which was the 103.85.
85.
Yep. And then what it took what was left over from that, if you do the math, is the 38.45. So it threw it toward the next month that was due.
Okay.
Which was
So
September 16th.
Got it.
So
So
what
you're
Yeah.
saying then is that your client's saying that he owed 65.60 in September of 2016, and then October, November, December, January, February, March, April, May, June, there were
Yep.
no payments. That it shows balance transfer to collections just to balance your books. Doesn't mean that there was any payments.
Correct. And so those are the
Okay.
amounts. If you took a highlighter and just did all balance transfer to collections and add up the balances for all of those months, and it's basically, it's about 9.5 months, a little more than that, of the amounts. And so, but I do think it's interesting to note that the defendant in the case made a payment in 2017, toward dues that were outstanding based on the billings that were sent to him, which are all attached. The billings just show incremental increases in the amounts that he owed, and those bills were sent consistently over time. And frankly, he responded to them by making a $200 partial payment, which, frankly, Judge, it seemed to me to be acknowledged the fact that these dues were outstanding, that he was a member of the union and that he was paying toward them. If he had made no payments, from the time we allege this is actually during the time frame, that we're alleging he owed the money.
So one more question for you before I start asking Mr. Lyday a series of questions, is that if the documentation from the first contract says he wants payroll deduction, that's the one we can't read, and the documentation from Lakeville, which is the one we can read, both say payroll deductions, how did it ever switch out that they weren't just taking it from his check?
Well, Judge, in 2012, the Michigan legislature did pass legislation that said that without consent, you cannot take money out of somebody's paycheck anymore. The MEA had it pretty good. They didn't have a collections department back in the 90s and 2000s because you were, pretty much you owed the money, they took it out of your check and you didn't have to think about it. And that's why what you see with regards to the defendant is that he is making these payments by mailing them in and by also emailing, or I think he did one online payment. I think he mailed some in. I think he paid in various forms, and those forms are identified within the ledger.
Okay,
Judge, a lot of the cases.
But the next question is, I understand the change in the law, the right to work legislation, and I'm not going to get to whole lot analysis there, but wouldn't it make sense that if you say I authorize my employer to deduct, that they agreed to the deduction? Or did they just say, we're just going to let you figure it out?
Well, the MEA basically told folks that if you wanted to continue to have the money come out of your check.
We're losing you, Mr. Cox. Wait just a second.
You could reauthorize that portion.
All right, so
we
lost you.
Well,
hang on, we lost you for just a second.
Can you hear me?
Yeah, I can now, but I couldn't there. You started saying the MEA's position basically was when the change in the law take place, and it happens. I mean, it's happened right now in the criminal law and landlord-tenant cases right now. We can't predict that when the change in law takes place, either by new legislation passing very quickly or Court of Appeals or Supreme Court makes a decision, we all have to react. So I get that. You're saying that there's no other document. In other words, the MEA didn't come out and say, well, here's how we're going to do payroll deduction, because they were faced with before in the past, it was pretty easy for them. They would just take it out of your paycheck. But after that legislation, we're not going to presume that this signature by you saying I authorize this is going to be good enough. So that at that point in time, they allowed other ways of payment.
That's right. And I've actually had dozens of cases with the with MEA where the members said, I thought they were going to just keep taking money out of my check. So I disregarded all the notices and I never paid because I didn't even know I had to make payments. But Mr. Zach knew because Mr. Zach was presumably responding to the billing statements. He was making payments. He was acknowledging that he was in the MEA, and he was acknowledging that by making the payments month over month, or at least periodically enough to keep current all the way into 2016, 2017, which is the 1 year that we show he didn't make payment.
All right. Mr. Lyda, your turn. So if your client says, hey, I'm out of the union, number one, I guess, what do we have an agreement on the date of when your client stopped being a teacher?
Yes, Your Honor. So this is actually when you placed Brother Counsel and I in the Zoom room or breakout room and the last MSD hearing to discuss resolution, we sort of clarified that. And I'll start by just making that clear for the record that there have been a miscommunication with the dates in which plaintiff was claiming, and we would agree that the dates that they are claiming are for when Mr. Zach was still a teacher.
Okay.
So that would render
27. He finished in 2017 at the end of the school year and didn't go back for 2018.
Yes, Your Honor.
Okay. So why shouldn't he have to pay if he was a teacher and he was part of the union?
Well, Your Honor, as you mentioned earlier, the membership application contains two very different sets of language for cash payment or payroll deduction. And the form contract only allows for the educators to select one of the below. Mr. Zach selected payroll deduction, which per the terms of the statute, it's 2012 PA 53. I think that's codified at MCL 423-210. It became illegal for a public school employer to deduct wages from to deduct wages from a public school employee for the purpose of union dues. The stark contrast between the language for cash payment, which states that membership is continued until reversing this authorization, that's very different language from the payroll deduction, which simply says that until such a time as they revoke the authorization in writing, then the membership is continued until such a time. Well, the right to work legislation and that legislation I mentioned earlier made that clause illegal. And the MEA never saw fit after that fact to continue and have Mr. Zach sign an updated contract. Mr. Zach never had agreed for continuing membership with regard to cash payments. Plaintiff cites on page 5 of his brief a portion of law that supposedly purports to require members of the union to submit written request for resignation. However, the cited case is SEA versus Edie Mayuski, but that case, that opinion from 2017 doesn't seem to contain any language to that effect. And that proposition, really that case stands for the opposite proposition, that educator opt out of the union, they have more freedom to do so. It struck down the August opt-out period. The other case cited is a federal case from 1990 before any of this other Michigan legislation took place. And just really briefly, Your Honor, the submission of the MEA Constitution, that's not binding law and shouldn't be considered so. It's not incorporated into this contract, and it wasn't produced prior to plaintiff's supplemental brief, which would be in violation of the court's scheduling order requirement to send over photocopies of any evidence. And so we would, ask that the court strike that from consideration.
So what are you're saying the Saginaw Education versus E.D. Miskasuwitz does not stand for that you have to submit a membership, resignation of your membership?
Now, Your Honor, I was unable to identify the cited block paragraph language that plaintiff purports in that case opinion.
Mr. Cox, can you help us out with the location of that citation?
Well, Judge, I guess I'm looking at where we have it in our brief as it pertains to what we have it, how we have it cited. I guess I'm relying on the site we have if in fact we need to produce a copy of the underlying Merck case there, and the cases we can do so. I didn't attach a copy of the actual opinion to the motion.
Yeah, we'll just look.
But Judge, I think what we're relying on is that, frankly, if the defendant's position is true and that, frankly, everybody, I don't know if they're alleging by operation of law that all these contracts became void or everyone was kicked out of the union when right to work was passed, because, that would be a pretty easy resolution to these cases by the higher courts would be just say, look, we don't have to decide any of these issues because all your contracts are void. We don't have anything to enforce. Why are you coming before the Court of Appeals with any of your issues? Because, everything was voluntary. And frankly, everyone could have just walked away at any time without saying a word because you weren't really in the union anymore. And instead, what the Court of Appeals said was, hey, if you're going to do a written opt-out requirement, that's reasonable because alternatively, we don't know who's on the rolls. And the legislature did not intend for everyone to be kicked out of the union and for the union to start over. Their union rolls didn't go to zero in 2013 and then have the unfortunate position of having to sign everybody back up. That's not what they did. They did the opposite, frankly. They gave everybody a way to get out if you chose it. And Mr. Zach was aware and frankly made payments and decided to stay in. And he was paying along until he wasn't. And the fact that he stopped paying, frankly, if he'd come forth and the argument here was I opted out over the phone with Bob and Bob didn't tell Steve and Steve was supposed to tell Larry. And that's a lot of the cases we have, Judge. I would understand that position a little better than the whole I was paying and I decided to stop. And guess what? I got you because even though whenever I called on him, I contract that we allege doesn't bind me to being in the union. And I think what the case law basically said was, hey, this opt-out provision being in writing is reasonable and for the reasons stated here. To the extent that the court needs this, the underlying case or whatever it was that we cited, I can provide that.
Okay. All right. Thank you. I have listened to the motion for summary disposition. I've read the documents. I've read the box and the continuing membership application pursuant to MCR 2.116 I2. I'm granting, I am finding against the plaintiff. The language in the contract, the drafter of the contracts, it is the plaintiff. Ambiguity is written against the plaintiff. It is read against the plaintiff. Here, the box that I think pins the language. There's nothing in the contract that says, number one, that this is a springing contract and that you will always stay in the union. I don't find it in here. I see due payment to the MEA, NEA are not deductible as charitable contributions for federal income tax purposes. However, they may be deductible under other provisions in the Internal Revenue Code and or the Michigan income tax provision. As participant in the local MEA, NEA early enrollment membership program, I'm able to receive prior to September 1st certain benefits normally available only to regular dues paying members of the association including coverage under the NEA Educator Employment Liability EEL program. As a condition of eligibility for these benefits, I agree to pay the appropriate unified active membership dues for the current school year in accordance with the regular payment procedures. That language, current school year, tells me that these contracts should have been done annually, not that once you sign one, you're always in. It says current school year in accordance. Should I fail to do so, there's a remedy. My eligibility to receive benefits under the NEA EEL program shall immediately terminate. In addition, I shall be held for the cost of any benefits that were provided to me under the NEA EEL program prior to September 1st. Here, the contract is not clear that this is a perpetual springing contract. It is an annual contract that should have been signed. There is no contract that was presented to the court for the school year up till 2017. Here, the remedy for non-payment was termination from the union, even if it were a springing long-term contract. Here, there is nothing indicating that how many years. There's no indication actually as the amounts that a person would have to pay for the benefits. This contract has problems. It was known to the plaintiff in 2012 that it has significant issue with all of the teachers in the state of Michigan. It could have decided to draft new language requiring the teachers, if they wanted to continue, to resubmit. I am not going to look at the constitution of an organization. Constitution of the organization binds the organization. It sets the structure for an organization. It sets the parameters for the organization. It determines the how the organization is going to govern itself. It is not binding on the individual. It is binding only on the individuals who are acting as part of the organization. It sets out the parameters. That's not binding. The case law that was cited here is not for me, because this is a breach of contract. The four corners of the contract do not show an agreement between a meeting of the minds showing that there was ability. There was no allegations in the complaint that indicated that he received some type of benefit in this school year. It just says a breach of contract. The contract would be valid if it were signed. I can't tell the length of time that it was supposed to be. I have seen no signature from the other party indicating that they were going to be bound by it, but the language by itself is clear. It is for membership dues for the current school year in accordance with the payment procedures. There's no contract that I see for school year 2017 or 2016, 2017, and therefore I am finding no cause of action through the immediate trial provisions of MCR 2.116I. Is there anything you'd like to place on the record, Mr. Lyday, to augment the record for your client?
No, Your Honor, I don't believe there is.
Mr. Cox, anything you'd like to place on the record to augment for your client?
Judge, only that I don't want to argue with the court. I think the portions of the contract the court is reading from are additional programs that are not the ones that we're attempting to enforce, but I think the court's ruling has been made with regards to the contract itself. I just wanted to place on the record that the portions that are annual that the court just cited are not the portions of the contract that we are attempting to enforce. That being said, my question is,
the one question I have,
the defendant will submit an order?
Yeah, yes. If the one provision, however, is that if you see and can point to the court in this contract where it says that it continues on, I'm glad to read it. I don't see it in here.
No, I just, when the court, I'm sorry, just when the court was reading some of the language that pertained to the EEL or the other provisions that the court, that the defendant could have signed up for that, but did not. I'm just saying plaintiff's position is it's the continuing membership. And so that was what provided that this would continue.
I do appreciate that. And I don't think you're inappropriately arguing your point. I think you're appropriately. Point to me in this document, where in the four corners does it say that I'm missing? Because I read every section, but should I fail to do so, my eligibility to receive benefits shall immediately proceed. Then you have two boxes to check. Cash payment. Membership is continued unless I reverse the authorization in writing August 1st to August 31st of each year, which was not checked. And then payroll deduction. I authorize my employer to deduct local NEA dues, assessments, and contributions as may be determined from time to time, unless I revoke this authorization in writing between August 31st and 31st of any year. So that's probably the provision that you're looking for. But when the statute then the statute changed in 2012, that made that portion of that document part of the contract unenforceable, which then left the plaintiff to make a determination that it should have reached out to its members and granted new contracts or requested new contracts. So I thank you. I did not read those last two parts, cash payment and payroll deduction, but the court's position is that once the 2012 statute came into place, the payroll deduction portion of it was deemed illegal. Typically, you read the contracts to leave them in place as best you can, and I find no other provisions in the four corners of that contract that say that is an ongoing one, and the language I read at the top was for 1 year. So I'm sorry, Mr. Cox, I didn't mean to interrupt you. Is there anything else you'd like to place on the record? I think you're frozen, so we'll wait just a minute.
Your Honor, we will need that emailed as well.
No, Judge. No, Your Honor.
Okay. Anything else, Mr. Leidy? You're going to prepare the order, Mr. Leidy?
Yes, I will, Your Honor. Do you have a preference as to 7-day order or approved as to form?
Mr. Cox, do you have a preference?
Oh, I don't, Your Honor.
Why don't you submit it? Why don't you submit it to Brother Counsel for him the opportunity to read it? Because I'm certain that if they decide to see if wiser minds than mine make a decision opposite of that, that language would be very appropriate that you both agree on.
Understood, Your Honor.
All right.
Thank you very much.
Thank you. And if you could email it when it's done, whatever form you decide to do, that would be 75civil@co.midland.mi.us.
Great, Your Honor. Thank you.
All right.
Thank you, Judge.
Thank you, Mr. Cox.
Have a good day.
You too. Mr. Thompson, you're here for, you filling in for Mr. Shefsky?
I am standing in his shoes today.
All right. Those are big shoes to fill. So let me call the case. This is the case of Midland Montessori School versus Jessica Bazelak, file 21-08762GC. Counsel, identify yourself for the record.
Good afternoon, Your Honor. Andrew Thompson, standing in for Patrick Shefsky on behalf of the plaintiff.
All right. Today's time and date for a motion for default entry. Mr. Shefsky, Mr. Thompson.
Well, Your Honor, this is a breach of contract case related to a stipend and repayment agreement. The case was filed on March 4th, 2021. The defendant was personally served on March 15th. The defendant has not appeared or otherwise responded. A default was entered on April 7th, and the defendant, as of today's date, still has not appeared or otherwise responded. The plaintiff is seeking a judgment in the amount of $16,270.92, which was the amount pled in the complaint, plus $315 in court costs.
All right. I will grant that by default. Let me just check to make sure. Trina, is there anyone that has appeared or is in the virtual waiting room?
No, Your Honor.
And Michaela, is there anyone in the courthouse, or I guess I'll ask Katrina because Michaela does not have the eye in the sky.
No, Your Honor.
All right. Then the default will enter in the amounts stated. I'll sign the order once it's been presented to me. Thank you.
We will do so. Thank you, Your Honor. Have a good afternoon.
Thank you. You too. We'll be adjourned.